Imagine this for a moment. Brazil's top prosecutor, the Procurador-Geral da República, a man whose job is to be the ultimate guardian of the law, stands up and makes a declaration. He suggests that when it comes to the most powerful judges in the land, the ministers of the Supreme Federal Court, only he should have the key to hold them accountable. Only his office, he argues, has the legitimacy to even begin the process of impeachment. It sounds serious, technical, like a move to protect the stability of the state.
Right, framing it as institutional protection.
Exactly. He's essentially positioning himself as the sole gatekeeper, the only one allowed to knock on that door. But then you pull out a law, one that's been on the books since 1950.
A pretty old law.
Yeah. And in plain, unambiguous language, it says something completely different. It says any citizen can file that complaint. Not a prosecutor, not a politician, but any citizen.
Any citizen. That's a big difference.
Suddenly, this isn't a technical debate anymore. It's a story about a door that has always been open to the public and a powerful figure suggesting it's time to change the locks. The question then becomes, why? Why try to take a power the law explicitly gives to the people and concentrate it in the hands of one man?
That is the core conflict we are diving into today. And look, this isn't just some squabble over legal procedure.
Right.
This is really about institutional equilibrium in Brazil. It gets to the heart of how the Brazilian legal system is, well, engineered, you could say, to manage this tension.
Tension between what? Exactly.
Between, on one hand, immense elite institutional power, especially power held by non-elected bodies like the prosecutor's office or the courts, and on the other hand, the basic demand for democratic accountability.
Okay.
So our mission, really, in this deep dive is to understand that institutional architecture. How did the public prosecutor's office, PPO, get so autonomous? How did the Supreme Court, the STF, become so powerful?
And why did this seemingly simple mechanism of public accountability, this 1950 citizen impeachment law, suddenly become such a major, threat? A threat that the head of the PPO actually felt compelled to try and basically kill it off.
Okay, let's unpack this then, because before we can really get into why the prosecutor tried to, change the locks, we absolutely need to grasp the immense institutional power he already has.
Exactly. That power is the backdrop for this whole confrontation.
We're talking about the public prosecutor's office, the Ministerio Público, and this phenomenon that legal analysts have actually given a name to, quasi-abdication.
Yeah, and to really appreciate the scale of the PPO's power today, you have to step back a bit. You have to realize this institution is basically built on a constitutional revolution.
A revolution? How so?
Well, before the 1988 Democratic Constitution, the PPO was, traditionally subservient. It was attached directly to the executive branch.
Like in most other democracies. Pretty much, yeah. Like in many established Western democracies, right. It essentially took direction from the president or from state governors. And that obviously limited its ability to prosecute high-level corruption within the government itself. You don't bite the hand that feeds you, right?
So the 88 Constituent Assembly, the people writing the new Constitution, they looked at that structure and thought, hang on, this is a bottleneck, that it stops real accountability.
That is precisely what happened. And the decision they made was frankly radical. They didn't just tweak it. They moved the PPO into its own separate, independent constitutional chapter.
Completely separate.
Completely detached it from the executive, legislative, and judiciary branches. And they built in these incredibly strong protection mechanisms against political interference. The idea was, look, we need to grant independence, real capacity to fight corruption.
So members of the PPO got tenure, independence, just like judges.
Exactly. Tenure, independence, the works. Built to withstand political pressure.
Okay, that sounds like, a necessary move if you're serious about fighting systemic corruption. But where does this quasi-abdication idea come into play? If they're fighting corruption, isn't that just good?
Well, yeah, the independence itself isn't necessarily the problem. The issue is the lack of corresponding accountability that came with it. They gained this immense autonomy, this huge toolkit of legal instruments, but without a significant increase in accountability mechanisms to balance it out. So the result is this really unique institutional setup, pretty much globally.
How unique?
You've got high autonomy, sweeping discretionary powers, and a massive range of issues the PPO can jump into. It's quite the combination.
So when analysts use that term quasi-abdication, what they're really getting at is that elected politicians, the principals, in political science terms, they delegated power to the PPO, the agent, but they gave them such a high degree of autonomy That the politicians can no longer meaningfully direct or crucially discipline the agent. They sort of lost control. That's the core idea. It's quasi-abdication, not total, because politicians technically still hold some levers.
Right, they do. They control the constitutional amendment process. They can change the rules of the game if they really want to, and they approve the final budget.
But even the budget isn't a strong leash.
Not really.
Yeah.
Even the budget process is kind of skewed in the PPO's favor because the office proposes its own budget.
Okay.
Which often leaves the legislature with very little room for, effective cuts without risking serious political backlash. Why are you cutting the budget of the corruption fighters? It's a mechanism almost engineered for self-preservation, for protection from political retaliation.
So for all practical purposes.
Of all practical purposes, yeah. When it goes down to investigations, deciding who to go after, the PPO acts largely as an unreviewable, autonomous political force.
Okay, that structural shield, that independence, lets the PPO be incredibly active across Brazilian society. Let's dig into their privileged means of action and discretion. How does this autonomy translate into, real-world power on the ground?
Right, we can sort of break down their functions into, say, 3 main domains. And each has a different level of discretionary control, which is key.
Okay, domain 1.
First, their traditional function. The public penal action for common crimes. Murder, robbery, that kind of thing. Here, their discretion is actually quite low.
Low? Why?
Because if there's evidence, they generally operate under what's called the principle of legality. Basically, they must submit the case to the judiciary. They don't have much choice.
So they have to prosecute if the evidence points that way.
Pretty much. That low discretion in this specific area of common crime, it does provide a kind of check against abuse. It keeps them focused on the facts.
Okay, so they're somewhat constrained by the evidence when dealing with everyday crime, but I'm guessing that changes when they start looking up the institutional hierarchy towards politicians.
It changes dramatically, yeah.
Yeah.
When they step into their role as an oversight or accountability agency, which is where they prosecute politicians, bureaucrats, for things like corruption, administrative misconduct, malfeasance.
That's where the discretion kicks in.
That's where their discretionary power just explodes. Especially when you look at civil legal actions, not just criminal ones. They have the sole right to decide which cases to pursue, which evidence to prioritize, and, maybe most importantly,
which cases not to pursue.
Exactly. Those negative decisions, the ones that stop an investigation dead in its tracks, maybe before it even really begins, those are often the most consequential. They define who gets protected and who gets targeted.
And that allows them to effectively, shape the political landscape, doesn't it? I mean, we see this all the time with high-profile corruption probes. The political damage is often done way before any judge actually rules on the case.
Precisely. The PPO holds an incredibly powerful tool, the ability to select the timing and the target of an investigation. They can strategically use the media, leaking information, announcing big, splashy operations.
Basically raise suspicion against a politician.
Yes. Effectively running a public opinion trial before any judicial verdict comes down. And if this happens, say, right before an election, or maybe before a critical vote in Congress,
the timing can be devastating.
Absolutely devastating. Regardless of whether the person is eventually found innocent years later in court, they can weaponize information and their institutional authority to exert huge political pressure. It makes them, arguably, the most influential political actor in Brazil that isn't subject to periodic elections.
Wow. It sounds like they're not just prosecutors anymore. They're almost political agenda setters.
They absolutely are. And, this leads us to their third role, which is often overlooked, but I think immensely powerful.
Which is?
Public civil action. This is where the PPO acts as a sort of defender of rights, bringing legal action about collective interests, diffuse interests, things like environmental protection, consumer rights, public health standards, a huge range.
Now, I know the PPO doesn't have a complete monopoly here. Other state bodies can file these kinds of actions too, right?
That's technically true, yeah. Other entities can use this tool. But what's the reality on the ground?
The reality is the PPO is the dominant player.
By far. Reports suggest they initiate something like 90% of these public civil actions. 90%.
Okay, so they drive the agenda.
But the key to their discretionary edge here, the real source of power, lies in their monopoly over something called the civil inquiry procedure.
The civil inquiry procedure, what's that?
It's basically the preliminary investigation stage for these public civil actions. Think of it as the pre-lawsuit investigation.
So they control the gatekeeping function, they gather the evidence, they decide whether to even proceed to court.
Precisely. They alone decide if a case has enough merit to be transformed into a judicial action, into a lawsuit. So if they find, say, a major environmental issue, or a big failure in public health infrastructure, or a large-scale consumer fraud,
They can force the issue by deciding to file suit.
they can compel action. And this is crucial because it means that these non-elected officials, these prosecutors, are effectively setting policy priorities. They're compelling state action through the courts, making decisions traditionally reserved for the elected majoritarian political branches like Congress or the president.
Right.
This widespread discretionary power across all these areas is a huge contributor to what people call the judicialization of politics, turning what should be legislative or executive policy debates or even failures into legal actions that end up having to be resolved by judges.
And this brings us, inevitably, directly to the courts themselves. Because if the PPO is out there aggressively filing lawsuits, setting policy through civil action, all that work eventually lands on the desk of the ultimate arbiter,
The Supreme Federal Court.
the STF.
Exactly. And the attempt by the chief prosecutor, the PGR, to control the STF's impeachment mechanism that really highlights this direct conflict over judicial power, doesn't it? It's like two giants eyeing each other. It absolutely does. So we really have to turn our attention now to the STF's structure. Because if the PPO is this powerful agent whose actions are, let's face it, difficult to review.
Then the STF is the ultimate judge whose decisions are incredibly difficult to overturn.
Right. But here's the twist. Despite its strong supremacy in certain legal areas, the STF also has these structural features that make it, in some ways, politically vulnerable
Yeah.
and subject to mechanisms that suggest a kind of weak form review.
Weak form review, what does that mean? Usually we think of the Supreme Court as anything but weak.
It's a term often associated with systems where the legislature ultimately retains the final say on constitutional matters, even after a court ruling. But let's start with the STF's dominance first. Brazil's system is often described as a hybrid judicial review model. What makes it so powerful?
Okay, hybrid, how does that work?
Well, it kind of blends two models. It takes the diffuse U.S. model where basically all courts can declare laws unconstitutional in specific cases they're hearing. And it combines that with the European abstract control model. That's where only the top court, the STF in this case, can directly strike down statutes or executive acts in the abstract outside of a specific case. And those decisions have binding effect across the entire system.
Binding effect, you mean everyone has to follow their ruling?
Yes, and powerfully so. The legal terms are ex tunc, which means the decision applies retroactively right back to the beginning.
Wow.
Erga omnes, meaning it binds everyone, the entire judiciary, the executive branch, everybody. Plus, since the 1988 Constitution, and really critically, since the 2004 judiciary reform that was called EC45,
EC45, okay.
the STF really cemented its supremacy.
How did EC45 boost their power, specifically?
Well, it established something called the general repercussion regime for appeals coming up to the STF. Basically, a way for the court to filter which cases it hears based on their broader importance.
So they can pick the big constitutional question.
Exactly. And maybe even more significantly, it gave the STF the ability to issue binding precedents, known in Brazil as súmulas vinculantes.
Binding precedents. So once the STF rules on something,
That ruling isn't just like persuasive guidance for lower courts.
Right.
It binds all lower courts. They have to follow it.
that sounds like, well, it effectively gives the STF a quasi-legislative function, doesn't it? They can standardize constitutional interpretation across the whole country without waiting for Congress to pass a law.
That's it. It's immense power. It cements what people often refer to as the court's strong supremacy.
Okay, so they have all this power, these binding precedents, abstract control. What did you say earlier? They're also structurally weak. That seems contradictory.
It does, but it comes down to the practical reality of their workload. Despite being the highest constitutional court, its workload is just massive.
Drowning in cases.
Pretty much. Analysts have crunched the numbers, and for years, something like well over 90%, maybe 92% of the cases hitting the STF were appeal cases. Individual cases just climbing the judicial ladder.
So most of their time isn't spent on those big, abstract constitutional rulings.
Exactly. It means the STF functions primarily as a kind of supreme appellate court, constantly dealing with this huge volume of individual legal disputes, rather than focusing purely on its core constitutional role.
So the court is swamped with appeals, which must, I imagine, diminish its capacity to really focus on that abstract constitutional control, the stuff that, sets the rules for the whole country.
Precisely. Those abstract control decisions, the ones that define the fundamental rules, often represent less than 1% of its actual case volume. So the STF is forced to dedicate enormous resources just to managing the caseload, which limits its ability to fully engage its primary constitutional function.
Okay, that's a practical weakness, but the structural vulnerability you mentioned before, the weak form review structure, that lies in how the Constitution deals with legislative failure, right? When Congress just doesn't act.
Yes, that's the core of it. Despite the STF's supremacy in striking down laws, the constitutional design includes these specific mechanisms where the legislature, the National Congress, structurally holds the final word on certain constitutional matters. And this primarily comes up when dealing with legislative omission.
Legislative omission meaning Congress fails to regulate a right that the Constitution guarantees, so the right can't actually be exercised.
Exactly. The Constitution promises something, but needs a specific law to make it work, and Congress just doesn't write the law.
Okay, give me a breakdown of those mechanisms. How does the system handle that?
There are two main tools. The first is the writ of injunction, or mandato de injuncel, usually called MI. That's an individual remedy filed by a citizen or a group whose right is being blocked by the lack of regulation.
Okay, an individual tool. And the second?
The second is the action of unconstitutionality by omission, or ADI by omission. This one is an abstract direct action, usually filed by high-level institutional players like the president, the PGR, political parties, etc.
Let's take the classic example often used for the mandato de injuncel, the right of public servants to strike. The '88 Constitution grants this right, but explicitly says it needs a specific law to regulate how it works. If the legislature just stays silent for years, what did the STF traditionally do when someone filed an MI?
This really reveals the historical structural tension you mentioned. Historically, especially through the 1990s, the STF took a position that legal scholars often call self-contained or declaratory.
Self-contained, meaning?
Meaning when an omission was declared, when the court agreed, yes, Congress failed to act here, it would basically just notify the legislature of its failure, and then it would transfer the final decision back to Congress, telling them to regulate the issue.
So they'd say, you failed, but then now go fix it.
Pretty much. The court argued back then that it had to defend the strict separation of powers. And since the required regulation, like, defining the acceptable limits of a public sector strike, which services are essential, what are the procedures, since that was inherently political and had budget implications,
the court felt it couldn't step in and basically write the law from the bench.
Exactly. They saw it as legislating, which wasn't their job.
But wait, if the court declares the legislature failed, but then just tells the legislature, okay, your turn now, isn't that just a polite slap on the wrist? Doesn't that make the whole MI process kind of toothless?
Yeah.
If Congress didn't act before, why would they act now?
It did make it largely toothless, and that's the very essence of the weak form review aspect. The STF's rulings in these omission cases were intended, in theory, to be provisional. They could easily be overridden by a simple majority vote in Congress if Congress ever decided to actually legislate.
So the court was prioritizing the structure, the separation of powers, over the immediate enforcement of the constitutional right itself.
That was the effect, yes.
Right.
But here's the kicker. The legislature almost never responded responsibly. The data clearly shows that legislative inaction just continued. It became the norm, which confirmed that simply signaling the omission, just telling Congress they failed, was basically useless.
So legislative failure, sheer inaction, basically forced the hand of the Supreme Court. That's what drove the change we saw around, 2007, 2008?
Absolutely. The sustained failure of the political branches, Congress, the executive, it forced the STF to fundamentally review its position. They eventually decided, look, the inability to exercise a constitutional right cannot result in such an extreme disadvantage for citizens just because the legislature is, inert or unwilling to act.
That sounds like a profound shift. The court decided it had to step into the void.
It was a huge shift. The court decided it had the duty to fill the constitutional void left by political failure.
So how did they actually fill that void? Let's stick with the public servant's right to strike example. What did the STF do differently after 2007?
In those really paradigmatic cases, the STF basically said, okay, Congress hasn't acted, we can't wait forever. So they stepped in and ruled that the existing law that regulated strikes in the private sector should be applied by analogy to public servants wherever possible.
So they borrowed a law from elsewhere to make the right effective immediately.
Yes. They created an immediate, enforceable legal framework where none existed before. And this was a massive judicial intervention that dramatically increased the STF's power. But, and this is important, it wasn't like a power grab or a coup.
It was driven by failure elsewhere.
It was driven by the continuous, sustained failure of the political branches to perform their basic constitutional duties. The court became activist in a sense, not necessarily because it sought more power, but because the structure of governance demanded an answer, and the legislature simply refused to provide one.
Okay, this whole struggle over policy, over political power, over who gets the final say, is it the autonomous prosecutor, the silent legislator, or the now activist judge? It really makes the mechanism of impeachment seem like the ultimate, maybe the only real tool of accountability for these powerful figures.
It really serves as the constitutional pressure valve, doesn't it? It's designed, at least in theory, to handle serious misconduct by the highest non-elected officials in the land. And impeachment in Brazil is inherently a political legal instrument.
Political legal, meaning it starts legal but ends political.
Kind of. It's initiated based on a legal complaint alleging specific crimes of responsibility. But the final decision, the judgment, is made by the Senate, which is obviously a political body. And it requires a hefty 2/3 majority for conviction.
And what are the actual consequences if someone is convicted in an impeachment trial? Is it jail time?
No, these sanctions are purely political. It's removal from office and then disqualification for 8 years from holding any other public position.
That's it? 8 years out.
That's the impeachment sanction itself. But, and this is critical to remember, that removal does not shield the individual from subsequent prosecution for any common crimes they might have committed. That can still happen in the ordinary court system. Impeachment is really aimed at institutional correction, removing someone unfit for office, not primarily at criminal punishment.
Right. Now, impeachment is often associated with presidents. Brazil has seen 2 impeached in recent history, but it's also the key mechanism intended for holding Supreme Court justices accountable for these crimes of responsibility. What specific kinds of acts can actually get an STF justice impeached? What counts?
The law, that 1950 law we mentioned at the start actually, details a pretty wide variety of offenses. They cover everything from judicial neutrality and process to personal decorum.
Like what? Give me some examples.
Okay, so for instance, they can be impeached for altering a decision or a vote they've already formally given, unless it's through a proper legal appeal process, or for rendering a judgment in a case where they are legally suspected of bias, having a conflict of interest.
Okay, basic judicial integrity stuff.
Right. But then there are others that touch more on their role in the political system. A really critical one, especially given the context we've been discussing, is exercising party political activity.
Ah, so the law explicitly demands political neutrality from the justices.
Yes, it tries to enforce that separation.
But we just spent all this time detailing how central the STF has become to political life, filling legislative voids, making policy-like decisions. That seems like a massive tension right there.
It is the tightrope they constantly walk. The law also holds them accountable for things like negligence of duty or behaving in a way that's incompatible with the honor, dignity, and decorum expected of their high office. Very subjective, potentially.
That's fair.
And furthermore, and this connects directly back to our earlier discussion about principle versus policy, STF justices are explicitly liable for all 12 specified crimes against budget law.
Crimes against budget law? Like what?
Things like exceeding budget appropriations without proper legal authorization or clearly infringing specific provisions of the budget law. So the highest court in the land, the one that might rule on the constitutionality of the budget itself, is also held accountable if it fails to adhere to strict fiscal discipline in its own operations.
Okay, that brings us right back, full circle, to the initial conflict we started with. The state attorney general the PGR, the head of that powerful PPO, he is also subject to impeachment, right?
Yes, the PGR can also be impeached, for example, for issuing a legal opinion when suspected of bias in the cause.
So you have the head of one incredibly powerful, autonomous, non-elected branch, the PPO, wanting the exclusive right to initiate accountability proceedings against another incredibly powerful, autonomous, non-elected branch, the STF. Why is that specific power, the power given to any citizen by the 1950 law, why is that the target?
Well, think about it. That initial contention from the PGR, that only he should be able to start the STF impeachment process. It's a direct attempt to institutionalize and therefore control the sole remaining avenue for broad, potentially unpredictable public accountability over the Supreme Judiciary.
Because the 1950 law is different.
The 1950 law is a complete anomaly in this high-stakes institutional game. It allows literally any citizen to file an impeachment complaint directly with the Senate, completely bypassing all the usual institutional gatekeepers, the PPO, the president, political parties.
So the prosecutor is basically arguing that this kind of chaotic, unfiltered mechanism, the citizen complaint, is dangerous, maybe destabilizing, and should be replaced by an orderly, institutionalized process that's controlled by the experts, namely his own office.
That's essentially the argument being made, yes. By trying to claim an exclusive right, the PGR is positioning his office as the only legitimate institutional gatekeeper. He likely sees this non-institutionalized accountability mechanism, the 1950 law, as a vulnerability, something that creates instability for the high court. And simultaneously, he probably views his own office as the only entity with the necessary clout and legitimacy to act as a counterpower, to wield that impeachment threat responsibly.
So it's a fundamental contest over who gets to define legitimacy and stability when dealing with such immense concentrated power.
Exactly. Who gets to hold the keys to the kingdom's accountability?
Right. Now, the fact that the STF is, seemingly constantly under threat of impeachment from various quarters and yet continues to intervene so actively in politics and policy suggests they must rely on a pretty powerful defense, a justification for their actions. What's the philosophical bedrock supporting this immense judicial power, especially when they're making decisions that, let's be honest, look an awful lot like setting policy?
Okay, yeah, that takes us squarely into the realm of neo-constitutionalism. This is really the dominant legal theory or philosophy in Brazil and in many other places too that supports this strong activist role for the STF.
Neo-constitutionalism, what's the core idea?
At its heart, it advocates for the omnipresence of the Constitution. The idea is that fundamental constitutional principles and rights aren't just abstract ideals. They permeate all areas of law. They should guide interpretation everywhere. It explicitly rejects the older, stricter separation between merely legal matters and constitutional matters.
So if the Constitution is everywhere, then judges, as its guardians, must also be everywhere, applying it to basically every problem that comes before them.
That's the implication, yes. The goal is to move beyond just looking at the black letter of the law, simple legal positivism, and actively ensure that fundamental rights and constitutional values are prioritized in every decision.
But doesn't that open the door to criticism?
Oh, absolutely. Critics argue quite forcefully that this road leads straight to what they call the dominion of the judiciary.
Dominion of the judiciary, meaning
a situation where non-elected judges effectively become a kind of moral vanguard, using broad, somewhat nebulous methods like weighting inflicting principles to impose their own unilateral resolutions on complex social conflicts that should really be hammered out of the political arena.
So the critique boils down to this is inherently anti-political, maybe even anti-democratic, because judges who lack direct democratic legitimacy end up replacing political bargaining and compromise with their own arguably subjective legal interpretations.
That is the core conflict, the central critique. And it raises a crucial question. If we accept the premise that courts generally shouldn't rule on pure policy, how can we possibly justify judicial decisions that clearly impact budgets, public health systems, environmental regulations, and so on?
Where does the philosophical legitimacy come from?
Well, the defense often rests heavily on distinguishing between principle and policy, a distinction famously articulated and developed by legal philosophers like Ronald Dworkin.
Okay, let's try and nail down that distinction because it seems absolutely key to justifying judicial activism or interventionism, whatever term you prefer. What counts as a policy matter that courts should stay out of?
Right. Policy matters are generally understood as those that involve a discretionary evaluation of consequences for society as a whole. Decisions about efficiency, about how best to allocate scarce resources, about setting budget priorities based on collective goals.
So deciding whether to fund, say, a new railway line versus a new network of hospitals, that's pure policy.
Exactly. That's classic majoritarian territory reserved for the elected bodies, the legislature and the executive, who are accountable to the voters for those kinds of choices.
Okay. And principle matters. Where does the court legitimately step in, according to this view?
Principle matters involve the consistent application of fundamental rights and the protection of equality. The argument is that when a court intervenes on a matter of principle, it's not creating new policy out of thin air.
What is it doing then?
It's enforcing the fundamental rights and values that the majoritarian populace already agreed to when they established the Constitution. So when a court reviews, for instance, the constitutionality of an annual budget law, it's not second-guessing the policy choices about spending priorities.
It's checking.
It's checking if those choices violate fundamental principles, ensuring the equal share of risk of harm for all citizens, making sure the government spending doesn't systematically violate core constitutional guarantees like dignity or non-discrimination. It's acting on principle.
So, in this view, the judge is acting as the ultimate guardian of the democratic consensus that's already embedded in the Constitution itself, protecting it from potentially short-sighted or unfair political decisions.
Correct. They intervene to uphold the established rules of the game against transient political choices that might undermine those rules. And this justification becomes arguably its most powerful, its most compelling, when courts are dealing with cases related to what's called the existential minimum of human rights.
The existential minimum, I've heard that term, it basically means the absolute floor of human dignity, right? The level below which the state simply cannot allow conditions to fall, no matter what the budget arguments are.
That's precisely it. It represents the absolute limit of discretionary power for the state. This concept defines a core threshold of human dignity that must be enforced, even when the government pleads lack of funds or says it's a matter for legislative discretion. This is often the philosophical shield used when courts intervene forcefully in areas like public health provision or, very commonly, prison systems.
And the example cited in the source material, the one about the prison in Rio Grande do Sul, seems to perfectly illustrate this high-minded philosophy crashing into, well, pretty ugly reality.
It is a really profound and quite stark illustration, yes. The Supreme Federal Court, the STF, was reviewing the conditions in a specific prison establishment. And the conditions were horrific, severe overpopulation, documented infestation of rats, a complete lack of proper sanitation, sewage issues. Just appalling.
And the lower court hadn't wanted to intervene.
The lower court had resisted ordering major changes, citing the financial limits of the state budget, essentially making the argument you described. This is a policy matter. It's about resource allocation. It's beyond the court's remit.
But the STF reversed that. They said, no, policy arguments stop here.
Exactly. The STF ruled unequivocally that these conditions constituted a clear violation of the existential minimum of human dignity for the prisoners. The ruling emphatically stated that the basic dignity of incarcerated individuals is not subject to arguments about financial constraints or budgetary limitations.
Did they address the money issue?
They did. Crucially, the court also noted that evidence presented showed that money had actually been allocated in the state budget for prison improvements, but had remained unspent, which completely undercut the lack of funds argument.
So it shifted from financial impossibility to political negligence or lack of will.
Precisely. It became a case of state failure, not state poverty.
That really clarifies the court's role in these extreme situations. They're acting in a counter-majoritarian way, perhaps, but not really to implement some new public policy they dreamed up. They're enforcing the absolute constitutional floor, the bare minimum standard of decency, against the sustained neglect or failure of the political branches. They're setting the basic requirements of a civilized state.
That's the critical distinction they would argue they are making. Yes. Setting the floor. Defining the minimum standard required by the Constitution itself. They see themselves as responding to a structural flaw in the system where the political branches consistently fail to protect the most vulnerable populations or refuse to regulate crucial rights, forcing the non-elected judiciary to step in and essentially govern by legal fiat to uphold those minimums.
So we've really mapped out quite a landscape here. We've discussed how the Public Prosecutor's Office, the PPO, acquired this vast, almost unchecked power largely through what's been termed political quasi-abdication.
Right, this delegation without sufficient accountability.
We've shown how the Supreme Federal Court, the STF, gained its own form of supremacy, rooted in neo-constitutional legal theory, often stepping into policy vacuums because the legislature simply failed to act.
Yeah, becoming activist almost by default sometimes.
And we've seen how this entire complex system kind of hinges on this surprisingly simple, potentially fragile open door for citizen accountability, that impeachment mechanism enshrined way back in a 1950 law.
That citizen power element.
And the attempt by the PGR, the head prosecutor, to close that specific door, to take control of STF impeachment, it really just seems like the latest, maybe the most visible move in this long-running fundamental contest. A contest over who actually gets to hold power, and maybe more importantly, who gets to hold the powerful accountable in Brazil.
It's true. The concentration of power we see today, both in the autonomous prosecutor and the activist judge, it was largely born out of the democratic promise of the 1988 Constitution. It was designed, in theory, to root out corruption and ensure fundamental rights were protected.
But there were side effects.
But the perhaps unintended side effect is that these non-elected institutions are now running vast swaths of public policy, often justifying their actions through high philosophy, like invoking the existential minimum when political will fails. And it means the balance of power is incredibly fluid, constantly shifting based on who chooses to act. The prosecutor, the judge, the citizen with that old law, or the perpetually silent legislator.
So when you boil it all down, what this really seems to come down to is a fundamental choice, or maybe a tension, between institutional efficiency and stability on one hand, and genuine democratic engagement and accountability on the other.
That seems like a fair assessment.
The tension we've explored between this strong judicial control, often justified by the sophisticated philosophy of principle versus policy, and the raw potential for direct citizen accountability through that 1950 law, that tension seems central to whether Brazil's legal system ultimately upholds democratic ideals or perhaps drifts towards being dominated by a kind of unaccountable, arguably enlightened elite. And the prosecutor's attempt to consolidate control over impeachment, even if argued in the name of stability or preventing frivolous claims, it necessarily implies a reduction of that direct public engagement. It means closing the very door the 1950 law explicitly sought to keep open, reminding us, I suppose, that institutional control and consolidation of power often come at the direct expense of popular sovereignty, or at least popular access.